All right, thank you all for joining us today. I'm A.G. Harmon at the Columbus School of Law at the Catholic University of America. And on behalf of the faculty, I want to welcome you to our second presentation in the Student Scholar Series this year. Please stay on mute until the presentation and response are over, and then I'll open the floor to questions, at which you'll signal to me with the raise hand feature here on the Zoom platform. This series was instituted 15 years ago now in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student Isabelle Colaiezzi. Is that right? Good. Before she begins, I'll introduce our respondent, Professor Susanna Fisher. Professor Fisher joined the faculty of Columbus School of Law in 1999, where she has taught copyright law, art law, entertainment law, introduction to intellectual property law, international intellectual property law, constitutional law, comparative constitutional law, civil procedure. I don't think she listed, she did first year property as well. I don't know that she's got that listed on here, but she's done a little bit of everything, so and can do everything, and we're glad to have her here, honored to have her here as part of the, she's done this for us several times, and honored to have her here today. So our student scholar today is Isabelle Colaiezzi. She graduated from the College of the Holy Cross in 2021, transitioned to law school immediately thereafter. During her time at the Columbus School of Law, she has served as a production editor for the Catholic University Law Review, a Dean's Academic Fellow, a Research Assistant, an Admissions Ambassador, and Fellow for the Office of Career and Professional Development. In her second year of law school, she competed as a member of the National Mock Trial Team and interned for Judge Richard J. Leon in the U.S. District Court for the District of Columbia. After graduation, she will be clerking for Judge John M. Gallagher in the U.S. District Court for the Eastern District of Pennsylvania. And following that clerkship, she plans to return to Washington to work in the litigation practice group of Morgan Lewis. Isabelle's decision to write in this area comes from and stems from her interest in her two favorite courses, administrative law and constitutional law. She found it fascinating to analyze a legal issue that would evolve throughout the writing process as the Supreme Court issued its opinion in Axon Enterprises, Inc. in April of 2023. So now I'll turn the floor over to Isabelle to present her work entitled The Thunder Basin Boom, Rethinking the Doctrine of Implied Jurisdictional Preclusion. So Isabelle, I'm going to turn things over to you. Let me make you the host. You are now the host, Isabelle. Thank you.
Thank you, Professor Harmon. Thank you for the introduction. Before I start, I would like to first thank Professor Squitieri, who served as my expert reader in my process of writing my law review comment, as well as Professor Fisher, who so graciously volunteered her time to be here today. As you mentioned, the title of my work is The Thunder Basin Boom. It's about rethinking the doctrine of implied jurisdictional preclusion. So I'm going to go ahead and share my screen now. Okay, are you able to see that all right?
You can see it.
Okay, perfect. To begin with, I would like to read my abstract from the article to provide a high-level overview of what today's presentation will cover. So this comment examines the limitations placed on federal district court jurisdiction over challenges to administrative agencies through the doctrine of implied preclusion, where it is unclear from the review scheme whether Congress intended to allow district courts to hear challenges to ongoing administrative proceedings. Courts have utilized a two-step approach from Thunder Basin Coal Company v. Reich to often reach a finding in favor of preclusion. This comment analyzes the evolution of the doctrine of implied preclusion, explains the most recent exception carved out in Axon Enterprise, and considers the jurisprudential flaws of the doctrine as it stands in 2020-24. It's helpful to begin with a brief overview of the administrative state. Administrative agencies are government organizations with the power to investigate, promulgate rules, and enforce statutory violations. Agencies have the power to enforce these statutory violations either by raising claims in federal district court or instituting their own adjudicatory proceedings that are similar to a trial. So how are these administrative agencies created? Under the purview of Article 1, Congress has the power to pass organic acts that establish administrative agencies and define the scope of their authority. These statutes set forth procedures for determining whether a party has violated a federal statute and what remedy the agency may provide. These adjudicatory proceedings most often take place in front of what is known as an administrative law judge or an ALJ. They are often appointed by the head of the agency. Within these organic acts, Congress also establishes a framework for review of administrative agency decisions. I provided an example of a common review scheme that you might find in organic acts, such as the Securities Exchange Act or the Federal Trade Commission Act, for example. First, after a hearing and examination of the evidence, an ALJ makes an initial finding as to whether the relevant statute has been violated. This decision may then be reviewed by a panel, board, or commission of the agency, and a civil penalty may then be imposed if applicable. Finally, if the party wishes to contest the final agency decision, they may raise this claim in the appropriate federal court of appeals. Justice Thomas refers to this review scheme as the appellate review model. Under the separation of powers framework established by the Constitution, there are distinct powers given to each branch of the government. Article 3 of the Constitution vests the judicial power in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Congress not only has the power to create federal district courts under the Constitution, but it also has the power to determine the cases that these courts may hear and when. The most prominent example of this is 28 U.S.C. Section 1331, where Congress gave district courts the broad authority to hear all civil actions arising under the Constitution, laws, or treaties of the United States. Conversely, Congress also has the power to limit district court jurisdiction. They may do so by limiting the ability for the district courts to hear certain cases by passing organic acts with specific review schemes that follow the appellate review model that was just discussed. I've included a quote here from a recent Supreme Court case that will be relevant for the presentation today that explains in simpler terms how these limiting statutes interact with the broad grant of power in Section 1331. In the Axon Enterprise Supreme Court case decided in 2023, the court said, a special statutory review scheme this court has recognized may preclude district courts from exercising jurisdiction over challenges to federal agency action. District courts may ordinarily hear these challenges by way of 28 U.S.C. Section 1331's grant of jurisdiction for claims arising under federal law. Congress, though, may substitute for that district court authority an alternative scheme of review. Oops. There we go. So how does Congress limit district court jurisdiction over agency action in practice? There are two ways by which Congress may do so: explicit preclusion of district court jurisdiction or implicit preclusion of district court jurisdiction. When Congress explicitly precludes district court jurisdiction over agency action, it uses clear and unequivocal language, often prohibiting any court of the United States from reviewing actions of that agency. However, the use of clear and unequivocal language is not the only method by which Congress can inhibit district court jurisdiction over agency action. Courts have long held that Congress may implicitly preclude initial district court review over agency action by establishing an alternative process of review, such as the appellate review model. Under the doctrine of implied preclusion, where the statute is ambiguous as to whether district court jurisdiction is permitted at all, courts must infer congressional intent from the language, legislative history, and context surrounding the statutory scheme as a whole. Thunder Basin Coal Company v. Reich, decided in 1994, is a landmark case for the doctrine of implied preclusion. Thunder Basin established the analytical framework for determining whether Congress intended for a statutory review scheme to strip initial district court jurisdiction over a specific type of claim. Step 1 of the analysis requires a court to determine if Congress's intent was fairly discernible from the statutory scheme. Step 2 of the analysis requires a court to consider 3 factors when answering the question of whether Congress intended for petitioners' claims to be reviewed within the statutory scheme. First, would all meaningful opportunities for judicial review be foreclosed? Second, are the claims wholly collateral to the agency's or to the statute's review provisions? And third, are the claims outside of the agency's expertise? The Supreme Court ultimately reached the conclusion that district court jurisdiction over petitioners' claims was precluded. However, step 2 of the analysis left the door open for a future finding in favor of pre-enforcement district court review, where the claim was unrelated to typical agency proceedings. In Free Enterprise Fund v. PCAOB, the Supreme Court identified one such instance where a claim was unrelated to typical agency proceedings, finding that the Securities Exchange Act did not preclude district court jurisdiction over petitioners' Appointments Clause challenge under Step 2 of the Thunder Basin analysis. The court determined that the Exchange Act did not provide a meaningful avenue of relief for petitioners' challenges because not all PCAOB decisions were reviewable by the SEC and that by extension, a federal court of appeals. The court also found the constitutional challenge to the PCAOB's existence was wholly collateral to the agency's proceedings and outside of the agency's expertise to review. In Elgin v. Department of Treasury, the Supreme Court held that the Civil Service Reform Act precluded petitioners' constitutional claims for equitable relief under Step 2 of the Thunder Basin analysis. These cases are known throughout my paper as the Thunder Basin progeny cases because together they established a framework for how the doctrine would have been interpreted for the following decade. So I've created a Venn diagram to illustrate how the Thunder Basin progeny cases compare to each other and to the Thunder Basin case itself. As you can see in both Elgin and Thunder Basin, the alleged constitutional violation came from the agency's conduct or enforcement of an allegedly unconstitutional federal statute. In Elgin, plaintiffs claimed that the statute was an unconstitutional bill of attainder and discriminated on the basis of sex. In Thunder Basin, plaintiffs claimed that the violation of due process, Fifth Amendment rights, as well as their rights under the National Labor Relations Act were violated. Free Enterprise Fund, on the other hand, involved a constitutional challenge to the agency itself, something that was not relevant to the merits of a typical PCAOB proceeding or the type of thing that the agency had expertise in resolving. For over a decade, the Thunder Basin decision controlled lower courts' interpretations of organic acts. Nearly all organic acts with review schemes similar to the Mine Act were interpreted as implicitly precluding district court jurisdiction. The Thunder Basin's Step 2 analysis was oversimplified and often led to what seemed like predetermined outcomes. Courts struggled to determine which factors should be given more weight than others. Many reached a consensus that preclusion was acceptable as long as a review scheme provided an opportunity for eventual federal appellate court review. This remained the case even where the other 2 Thunder Basin Step 2 factors appeared to point in the opposite direction. Free Enterprise Fund held very little precedential value, and as a result, litigants with similar constitutional challenges to the structure or existence of administrative agencies were forced to endure years of litigation in front of the very same agencies that they alleged were wielding unconstitutional authority. The very same agencies that played the roles of investigator, prosecutor, and judge in their cases. What's more, these agencies, like the Securities Exchange Commission, for example, were known to rule in their favor in 90% of cases resolved through their internal adjudicatory proceedings. This slide illustrates the timelines of 2 particular individuals, Raymond J. Lucia, an investment professional, and George Darkesi, a hedge fund manager. Both of these 2 individuals were investigated by the SEC ultimately found to have violated federal securities laws, but were required to exhaust their administrative remedies before they could receive relief from an Article III court on their structural constitutional challenges. After 8 years of litigation with the SEC, Raymond Lucia reached a settlement agreement whereby the SEC would resolve all claims against him if he agreed to pay a penalty of $25,000 and to drop his affirmative case against the agency. George Doctrine has been involved in litigation with the SEC since 2011 and is awaiting relief currently in a pending Supreme Court case that is to be decided this summer. The claims he has raised are as follows: that the administrative enforcement proceedings initiated by the SEC seeking civil penalties violate the Seventh Amendment, that the Organic Act, which provides the SEC with an option to enforce federal securities laws in its own adjudicatory proceedings, violates the non-delegation doctrine, and third, that Congress violated Article 2 by granting for-cause removal protection to ALJs in an agency whose heads enjoy for-cause removal protection. It appears that the court's decision will be largely focused on resolving the Seventh Amendment issue. The cases of Raymond Lucia and George Doctrine demonstrate the negative implications that preclusion of district court jurisdiction has had on individual litigants with constitutional claims to the agencies investigating them. In 2023, the Supreme Court carved out an exception to the doctrine of implied preclusion as it had previously stood. In Axon Enterprise Incorporated versus the Federal Trade Commission, the court held that the Exchange Act and the FTC Acts do not preclude district courts from hearing collateral constitutional challenges to the structure or existence of the SEC and the FTC. Each suit charged that some fundamental aspect of the commission structure violates the Constitution, that the violation made the entire proceeding unlawful, and that being subjected to such an illegitimate proceeding causes legal injury, independent of any rulings that the ALJ might make. The aggrieved parties, Axon Enterprise and Michelle Cochran, argued that there was federal district court jurisdiction to resolve their claims of unconstitutional ALJ removal protections under 28 U.S.C. Section 1331, despite the respective agencies' statutory review schemes. The Supreme Court distinguished these cases from Thunder Basin and Elgin and adhered to the logic in Free Enterprise Fund, recognizing that the injury plaintiffs were asserting was the harm that would come from being subjected to an unconstitutional administrative proceeding, as Raymond Lucia and potentially George Doctrine had. The court referred to it as a here and now injury because it cannot be remedied after the fact. Administrative proceedings cannot be undone. So the only remedy is to allow pre-enforcement review of their claims in district court to protect litigants' right not to endure a potentially illegitimate proceeding. After the Axon decision created an exception for immediate district court review of structural constitutional challenges to agencies, it remains unclear how far this holding will extend. For example, how should other types of claims arising under federal law or the Constitution be resolved? Concurring in the opinion, Justice Thomas pointed out that the disposition of private rights to life, liberty, and property was traditionally understood to fall within the core of the judicial power. Justice Thomas appeared to not believe that the degree of judicial review outlined in these organic acts or enabling acts can ever be meaningful in the case of private rights. Justice Thomas also argued that standard for judicial review outlined in these administrative schemes is too deferential as applied to adjudication of private rights. In Justice Thomas's opinion, these schemes do not allow for, quote, full Article III adjudication, unquote, because the reviewing court cannot take its own evidence and must apply a highly deferential standard that practically treats the agency's finding of fact as conclusive. Finally, Justice Thomas argues that private rights should be entitled to full Article III adjudication at the risk of violating the separation of powers. Concurring in the judgment, but not in the opinion, Justice Gorsuch advocates for strict adherence to the broad grant of 28 U.S.C. Section 1331's conferral of jurisdiction and the overturn of the Thunder Basin framework altogether. He takes issue with the Thunder Basin rule because it's both unclear and difficult to apply for lower courts. He also argues that it's harmful to the parties who are forced to endure these years of litigation. Justice Gorsuch believes that the Thunder Basin analysis shifts the focus towards litigating which court has jurisdiction to hear the plaintiff's claim, rather than litigating the actual merits of their constitutional challenge. Justice Gorsuch stated, jurisdictional rules, this court has often said, should be clear and easy to apply. Justice Gorsuch also stated in this opinion, like any needlessly unclear jurisdictional test, Thunder Basin carries with it real costs for individuals seeking to vindicate their rights, for lower courts who deserve better guidance, and for our legal system's promise of a just, speedy, and inexpensive determination of every case. Should the Supreme Court decide to adopt either of these approaches when the opportunity presents itself in the future, it is likely that we will see a rise in agency enforcement actions brought in district court to avoid the time and expense that comes from having collateral proceedings. If Congress is concerned with undermining administrative proceedings or flooding the district courts with these cases, it may seek to amend the language of these review schemes to explicitly preclude district court jurisdiction over agency action. Nonetheless, it is unlikely that they will be able to explicitly preclude district court review over structural constitutional challenges in light of the Axon decision. Finally, I have attached a bibliography of the sources I used in today's presentation, and I wanted to thank you for your time and attention.
Thank you, Isabelle. If you would turn the hosting duties back over to me, I will I'll then turn the floor over to Professor Fisher. And Professor Fisher, once she unmutes herself, she will conduct a 10-minute or so response, and then we will open the floor to questions. So, Professor Fisher.
Yes, hi, everybody. I'm so pleased to be here to honor Isabelle's excellent work on this paper. I got to get to know Isabelle as a student this fall in my music law class, and that class had a lot of writing assignments. And so I was able to experience quite a lot of Isabelle's excellent writing, which is really, very high level when it comes to her ability to clearly explain and analyze complex legal doctrines like implied preclusion. So I know she's going to be a great help to her judge as a law clerk and to her law firm when she returns to Washington, D.C. And I think you could see, how clear she is. This ability when you saw how she laid everything out in the PowerPoint slides, which I just thought really got to the heart of everything in the paper. So I want to ask you some, few questions, and then, after that, we'll, allow everybody who's listening to ask some more questions. So the first question is kind of a writing process question that I thought might be of interest to some of the students who are here, who might be thinking about writing a paper like Isabelle's. Students often shy away from writing about a pending Supreme Court case because of the fear that their article will be mooted by that case. Why did you decide, Isabelle, that it was still important to write an article on Axon while it was still pending?
Well, thank you, first of all, for the very kind words. I really appreciate that, and it's been such a pleasure to work with you this year. As far as it goes with writing about an issue that had the potential to become moot, it was a difficult choice for sure, but I was excited to take on the challenge because I knew that this made it a 2-year-long ordeal for me. It meant that I had something that I was really interested and involved in, and it gave me something to look forward to continuing to work on in my 3rd year. I was able to read the oral arguments and listen to them when they happened, and I read the transcripts. I was able to listen to podcasts and read articles where they were predicting how the Supreme Court would come out. It really gave me an insight as to what practitioners do, especially appellate practitioners, when these decisions have such a large implication on work for their clients. And it gave me that sense of connection and passion to an issue that I was able to constantly stay up to date with what was happening, and then able to go back, reread my paper, see what I got wrong, what I got right, and essentially make it less of a paper about predicting what the Supreme Court would say and kind of alter it into discussing what they didn't say and what's left to be decided. So it was a challenge, but I really enjoyed it because it gave me something that wasn't just a paper that was a law review comment and done with. It was something that I was able to continually go back on and expand my knowledge of over these past 2 years.
Yeah, that's really interesting. I think it's great advice to people who are, coming up and thinking about writing papers, not to be scared if the case is pending, that actually it's a great opportunity. And, I'm hoping that, as Professor Harmon and I had both discussed with Isabelle, that she might consider writing something, turning her paper maybe into something for practitioners, like as a bar review piece, so she can talk about some of the open issues that remain that are really important to practitioners, somewhere that they will actually read. So I'm really hoping that you might be able to cut the paper back in size and scope and do that. So the cases that were consolidated in Axon were both procedural cases, and both were remanded back down to the respective federal circuits, Court of Appeals, to go forward on the substantive constitutional challenges to both the SEC and the FTC proceedings that had been consolidated in Axon. So I believe that the FTC dropped its case in the fall of 2023. So that constitutional challenge will not go forward substantively. Do you know what's going on with the SEC constitutional challenge at this point?
Yes, I did some research regarding that challenge because it was so interesting to see. I think the plaintiff in that case, Michelle Cochran, had a similar timeline to Raymond Lucia and George Darkezzi, who I alluded to in my presentation, that she had a very long battle to get all the way to the Supreme Court. And ultimately, they remanded the case back down for the district court to review. Ultimately, I confirmed with the press release from the attorneys representing her at the NCLA, and they did reach a joint dismissal and agreement with the SEC to drop her case against them in exchange for them agreeing to not pursue further administrative action against her.
Oh, that's interesting. But of course, we still have Darkezzi, pending. That's going to answer a lot of the substantive questions for us very soon, probably, in a month or couple months or so.
Yes.
Do you think it's likely, Isabelle, that the Axon case will open the floodgates of many constitutional challenges to federal agencies beyond the FTC and SEC that have these similar judicial review mechanisms whereby their final decisions are subject to review by Federal Circuit Court of Appeals, but they're, because I think there are a lot of agencies that are structured that way, like the consumer, CFPB, the EPA, the FAA, the Federal Communications Commission, the Federal Energy Regulatory Commission, and so on. So that's really a lot of our important agencies. Do you, are you aware of any actual post-Axon structural constitutional challenges to any federal agencies beyond the SEC and FTC?
Yes, I had also been looking into this as well. I thought that this was incredibly interesting to see. I believe a lot of people anticipated how the Supreme Court was going to come out on this decision, and were in similarly situated positions with a pending investigation, that they were able to leverage this decision to raise their claims in district court collaterally. The ones I have seen were, I saw the FDIC, the FERC, National Labor Relations Board, National Securities Clearing Corporation. I've seen quite a few, but none of them, I think the interesting part is how the agencies are going to respond when it's just at the district court level. It has to be appealed. It has to be, reviewed and affirmed ultimately by a circuit court. And then for it to really probably warrant a full change in the agency's structure would probably need to make it to the Supreme Court. So I think the interesting part is how many district court cases I've seen filed, but I'm not sure how the district courts in the long term are going to respond to each of these individual challenges, and if the courts as a whole, the federal court system, is prepared to review all of these administrative acts with very similar review schemes. Because from my research, it appeared that this appellate model of review was one of the more common, as well as the ALJ and the formal adjudicatory proceedings were pretty similar to what we saw in the Exchange Act and the FTC Act.
Yeah, and it's really gonna, shift maybe the way that the agencies allocate their resources as well. Some people have posited that maybe, like say in the SEC, it will shift resources away from investigations that they are doing towards litigation, which is, remains to be seen, obviously. You had talked about Justice Gorsuch's concurrence in Axon, where he takes a position on, that, we can sort of look at this a lot more simply than maybe we are already. He takes the position that whether district courts have jurisdiction over constitutional challenges to administrative proceedings can just be determined very simply according to this broad grant under 28 USC section 1331 that's, gives all district courts jurisdiction very, very broadly. What do you think the pros and cons are of following that approach?
I think the pros apply a lot more to the district court level. I think the pros are judicial clarity. These district courts aren't tasked with making these really in-depth and slightly subjective determinations as to what Congress meant when it did or didn't include a specific word or mention the district courts in the statute. So I believe that the pros in that case are helpful to the district courts in being able to have a clearer rule that we're allowed to decide this case. It's a constitutional claim, very clear under 1331, this is acceptable. I also believe it creates more predictability, which is important for litigants raising these claims and taking the time and expense to bring them to the district court when they know that they don't have that jurisdictional barrier. I think, as Justice Gorsuch pointed out, it does seem like a lot of time was spent leading up to, and then the Thunder Basin boom period, a lot of time was spent litigating jurisdiction rather than litigating the merits of these constitutional claims. So by the time the claims finally do get jurisdiction and make their way up to the Supreme Court, it's 10 years later. So I think the pros in that sense are expediting the process in terms of just clarifying judicial jurisdiction and understanding, okay, this can come in the district court. As far as the cons go, I believe that that's a policy effect, and that the floodgates would open. I think that you will see then a lot of plaintiffs raising their claims just right in district court, raising structural constitutional claims, maybe that they are less stronger claims, but they're just hoping that it's hoping to get them delay their administrative process, hoping to kind of undermine the administrative proceedings. And I think that that could have the effect also, as you mentioned, now these administrative agencies are going to fear that these constitutional claims are coming, that jurisdiction, no matter what, if it's under the federal statute that they enforce, can be brought, a challenge can be brought in district court. They're probably going to be reluctant to institute their own internal proceedings. They will instead bring theirs to district court as well to avoid collateral proceedings. So I think that for statutory interpretation purposes and for the purpose of the doctrine, it makes a lot of sense what Justice Gorsuch advocates for, but I don't know if our district court system is prepared to take on the amount of cases that that approach would require them to review.
Yeah, that's really interesting because it's, I think we're actually already seeing the SEC, for example, doing this.
Yes.
Opting for the district court right away. As they said in the very beginning, they have the option to do. So I guess my final question to you before we open the floor to other people to ask questions would be just generally, what advice do you have for your fellow students who will be writing a research paper, like a law review, comment, or note?
I think that it is very important to pick a topic that you're interested in right out of the gate. I was in administrative law at the time that we were selecting our topics, and it immediately piqued my interest. I liked the intersection between constitutional law and administrative law. I also, at that point, had considered clerking for a federal district court judge, so I loved the idea of kind of studying something that might someday have an impact on the work I'm doing. So I think the important part and the piece of advice I would give to students, in my position 2 years ago, would be to pick a topic. If it takes a lot of time, my process, I didn't pick one super easily. I had to do a lot of research to find an administrative law topic that really interested me and that was able to be expanded on. And I think I would encourage them to be patient with the process, to explore the network within their school and the mentorship. I was able to find great professors that assisted me in understanding this. And I think that your expert reader and the mentors you have are such an instrumental part in this process, because they're the ones who are helping you understand what you're writing about, conceptualizing these different, very complex issues. And if you have the right, something you're passionate about and the right mentors and support system behind you, I think it makes all the difference. And now I believe this has prepared me for what I will experience when I'm at a district court. I will be able to now understand this, and I've now gotten a far better understanding of the structure of administrative law after writing this paper.
That's great. And, I think we are so lucky to have Professor Scudieri here with his expertise in administrative law and his willingness to help supervise the law journal in general and help students in the way that he helped you. So
Absolutely.
that's really great. So I'm going to turn the floor back over to Professor Harmon.
Of course, a very fascinating and ambitious topic. I want to congratulate Isabelle for doing this, and I can vouch for her ability to write and as we can see, also to present her thoughts so cogently. She came to our judicial clerkship opinion writing conference this year, and so she is ready to go and to serve in the capacity of the clerk this coming year. And of course, I know Morgan Lewis is looking forward to her joining them after that. She'll be a proud alum. So thank you, Isabelle. Thank you, Professor Fisher. Thank you for all coming in today. Look for this story that will be on our website, and this YouTube video will be on the school's YouTube channel. So thank you all. We'll have one more presentation before the year ends. Bye-bye.